John Farrell with the Farrell Law Firm. Today we're going to talk about what assets should stay out of your trust. But first, make sure you subscribe to the channel. We put out new videos almost every day. And make sure you hit the like button because, hey, every like helps. John Farrell with the Farrell Law Firm. To tell you a little bit about myself, I'm the author of Estate Planning for the Modern Family and was recently voted one of the top lawyers here in Cobb County, Georgia, along with the law firm being voted one of the top law firms here in Cobb County, Georgia. Today, we're going to talk about what assets should stay out of your trust. We're going to quickly discuss what a trust is, why you would want a trust, what makes a trust work, and then what assets should stay out of your trust. By the way, if you want a cheat sheet on what goes into a trust and what stays out of it, subscribe to our newsletter by clicking the link and we'll make sure you get that cheat sheet. Okay, so what is a trust? Well, there's many types of trust, but what we're talking about today is called the revocable living trust. It is the most common type of trust out there, and this trust is used as a probate avoidance instrument or document. It gives you greater control over your assets if you become incapacitated and after you've passed away. It's a legal document that should be drafted by an experienced estate planning attorney. The reason you would want a trust like this is because it helps your family avoid the probate process. The probate process is what families have to go through when they lose a loved one, and that loved one had assets in their own name. You want your family to avoid the probate process when you pass away because probate can be costly and time-consuming. It takes about a year to a year and a half here in Georgia. Now, don't write in the comments that your family only took 6 months to go through the probate process because every case is different and some are shorter than a year and some are actually much longer than a year. A year to a year and a half is just the average. So avoiding probate is an important reason to have a trust because nobody has ever said, boy, I can't wait for my family to have to go to court when I pass away. It's not the type of legacy you want to leave. Next, if the trust helps your family avoid the probate process, how does it do it? As I mentioned a few minutes ago, your family will have to go through probate if you pass away with assets in your personal name. The idea behind the trust is you take those assets out of your name and put them into your trust name. Maybe it will be called something like the John and Jane Doe Revocable Living Trust. Since the asset isn't in your name when you pass away, that asset doesn't have to go through the probate process. In order to make the trust work, you have to put your assets into the name of the trust. In other words, you retitle those assets from your name to the trust name. This process of retitling your assets is called funding the trust. It is necessary to have a fully funded trust for your family to avoid visiting the probate court when you pass away. But there are certain assets that you do not put into the trust, so let's go over them. First, very quickly, the assets you should put into a trust are things like your home, bank accounts, certain investment accounts, and other things. Let's talk about the things you do not put into your trust. The first financial instrument that should stay out of your trust is a retirement account. We're talking about things like your IRA and 401k. You would not retitle the ownership of those accounts from your name into the trust name. The reason is doing that would have a very negative tax consequence, and the benefit to avoiding probate with that instrument is lost by the tax hit you'll take when retitling the ownership of that account from your name into the trust name. The next thing that should stay out of your trust is a life insurance policy and an annuity. The reason you wouldn't retitle the life insurance policy or an annuity into the name of the trust is because you can name beneficiaries on those two items and it will avoid probate anyway, as long as you name the beneficiaries correctly. By the way, you can name beneficiaries to your IRA and 401k. Now, just because you can name beneficiaries to your life insurance policy and annuity doesn't mean you disregard it altogether when it comes to your estate planning. Most people will change the beneficiary on those items so that it goes to the trust when they pass away. That way, those two items are filtered through your trust to the beneficiaries instead of just going to the beneficiaries outright. The last thing we're going to talk about not putting into your trust are your vehicles. This is a question I get all the time. Should we put our vehicles into the trust? The answer is no. Your vehicles should stay out of your trust. There's two very good reasons for not putting your vehicles in your trust. First, it's relatively easy to remove a deceased person's name from the title, and typically it does not involve going through the probate process. When that happens, you can Google something like Georgia deceased vehicle title, or whatever state you're in. And the first web page that pops up is usually the Department of Motor Vehicles or the Department of Revenue. And there's typically some simple instructions on how to remove the deceased person's name from the title, and it's typically a very easy process. Over the last 20 years, I've only had a couple of people complain about having to go through that process. The second and maybe more important reason is we've learned over the years that if you put your vehicle into the name of the trust and you get into a minor fender bender, it may encourage a lawsuit when they see the vehicle is owned by a trust. They see it's owned by your trust and think maybe there's some money here, so it encourages lawsuits for even things like minor fender benders. That's really all we have to talk about today. If you've watched our videos for any amount of time, then you know what we do is we help people plan their estates. To do that, we've created a book called Estate Planning for the Modern Family. You're going to want to get a copy of this book, so I'm putting a link in the description below so you can order it online. It will tell you all about wills, trusts, powers of attorney, and the probate process. It also comes with a bonus. The bonus is if you have trouble sleeping at night, you can read it and it will get you right to sleep, so make sure you read it in the morning. If you want to learn a little bit more about the firm or maybe schedule a free consultation for yourself, give us a call at 678-809-4922. That's 678-809-4922. I'm also putting a link in the description below so you can reach out to us to schedule that free consultation. All right, that's all we have for today. Make sure you subscribe to the channel because we put out new videos almost every day. And make sure you hit the like button because, hey, every like helps.